When is the best time to file for bankruptcy during a divorce?
It does make a difference whether to file a bankruptcy before or after a divorce, and whether it makes sense to file before or after really varies case by case. But in general, it makes sense to file for bankruptcy before the divorce is finalized, and there are a couple of reasons for that. But there are a limited set of circumstances where it might make sense to do the divorce first and then file bankruptcy. Typically, filing bankruptcy before divorce makes sense if both spouses are on board with the bankruptcy because there are debts in both spouses' names, either because they have approximately half of the total amount in each of their names, or if most of the debt is held jointly by both of them. And when I say that the debt is held jointly, it means that when the credit card or loan was opened on the application, both people put their social security numbers on and signed, and that one spouse wasn't merely an authorized user, but that the account was opened under both of their social security numbers. If the circumstances are such that most of the debt is joint, or there's approximately some debt is in some spouse's name and some is in the other spouse's name, you can discharge those debts with one single bankruptcy case. You can file a joint bankruptcy while you're still married, which is going to save you money because you're filing one case as opposed to two separate cases with two sets of attorney's fees and two sets of court filing fees. So you're going to save money on the bankruptcy case, and you're probably going to save money on the divorce as well, because if you retain a divorce attorney, part of what you're paying that divorce attorney for at an hourly rate is negotiating who pays what debts. If the whole debt situation is discharged by the bankruptcy and resolved before the divorce, then there is less for the divorce attorney to negotiate and less divorce attorney fees for which to pay. Another reason why filing for bankruptcy before divorce often makes sense is because when the debts are resolved through divorce decree, each spouse is required to hold the other spouse harmless from collection of the debt. Essentially, the court is taking a split the baby approach and assuming that both spouses are earning incomes and they're relatively earning the same amount. The bankruptcy court will say to one spouse, you pay these debts, and to the other spouse, you pay those debts. And for the debts that a spouse is paying, they are to hold harmless the other spouse from any kind of collection effort from those creditors. Well, if the divorce decree goes through and they're ordered to pay a portion of the debt and hold the other spouse harmless, and then that person tries to go and file for bankruptcy, they can file the bankruptcy, but bankruptcy doesn't erase debt. It discharges one's liability under a debt. And what that means is the creditors can no longer hold you responsible for the debt. However, if the divorce decree says that there is a joint debt and you are ordered to pay it, once the bankruptcy is filed, all that creditor is going to do is just turn their attention to the other person on the debt. They're going to begin collecting from that person. And if the divorce decree says that you are to hold that other person harmless, then the other person can go back into divorce court and say, hey, you ordered that my former spouse pay this debt and hold me harmless. He or she is now filed for bankruptcy protection and they're coming after me. He has to pay this debt. And the divorce courts oftentimes will say, yes, we're going to uphold this against you. And even though you filed bankruptcy, you've got to hold your former spouse harmless. And it's a way that an end run can be done around the bankruptcy. And so this is why many times it makes a lot of sense in terms of timing to file the bankruptcy before the divorce.